Would everyone ensure that all electronic devices are turned off or switched to silent? Tea and coffee is not allowed in the committee room. We are continuing the line-by-line consideration of the terminally ill adults end-of-life bill. I remind members that interventions should be short and raise points of clarification or questions. They should not be speeches in themselves. Members who do wish to give a speech should bob and to continue to do so through the whole debate in which they wish to speak until they are called. And when members say you, they are referring to the chair. You should not be used to refer to one another. The debate should be through the chair. We now continue the debate on Amendment 457 to Clause 13 in the name of Sarah Olney, with which it will be convenient to consider Amendments 471, 316 and 374. The question has just been proposed that the amendment be made, so I ask members to now bob to indicate if they wish to take part in the debate. Naz Shah.
Thank you, Chair. I'd like to speak in support of Amendment 457 moved by the Honourable Member for Richmond Park. As we have heard from the Honourable Lady, her amendment concerns the second period for reflection under the bill as drafted. The second period of reflection would take place after the panel had approved a person's application for assisted death. The bill states that this period would be 14 days unless the coordinating doctor reasonably believes that the person's death is likely to occur before the end of a period of 1 month, beginning the day that the declaration was made. In that case, the second period is shortened to 48 hours. Some people who have a strong desire to hasten death might wish to avoid the second period for reflection. If they refused food, there would be a strong possibility that their physical condition would deteriorate so that a doctor would indeed believe they were likely to die within 1 month. This is not, Chair, a hypothetical possibility. We know that there are people who do refuse food to the point where they become gravely ill with malnutrition. The Right Honourable Member for North West Hampshire said something which I think is very relevant here. The Right Honourable gentleman was asking questions of a witness before this committee, Professor Nicola Ranger of the Royal College of Nursing, on the 28th of January. And he said, I quote Hansard's account, "At the moment, within palliative care and palliative nursing generally, you are already dealing with patients who are electing to refuse treatment, food and water, or are supporting patients following an advance directive." On the same day, he also said something very similar to another witness, Dr. Sarah Cox. And again, I quote from Hansard, "I want to pursue that point a little with you, Dr. Cox. My understanding is that your profession is already taking these decisions or supporting patients to take these decisions. For example, the withdrawal of ventilation for an MND patient towards the end, or if I decide to decline treatment of food and water to end my life as quickly as I can." In other words, it is not the same remote possibility, it's not some remote possibility that patients who are already ill may decide to refuse food. That is one thing I hope that the Honourable Gentleman and I can agree on. We also know from the survey undertaken by a group of specialists in eating disorders that in countries which do have assisted dying laws, at least 60 people have qualified for assisted death because they suffered advanced malnutrition. Some people who are seriously ill will and who wish, in the words of a psychiatric witness, to hasten death may see the 14-day period as intolerable. It is an alarming possibility that they might stop eating in order to worsen their physical condition and qualify for the 48-hour period. The Honourable Lady's amendment would remove this possibility, and I strongly recommend that the Honourable Members on the committee support this. People would qualify for a shortened period for reflection only if they, to quote the Honourable Lady's amendment, have not voluntarily stopped eating and drinking. That word, voluntarily, is very important. I understand the reason that the bill's drafters put in a provision for a shorter second period of reflection, but as with much of the rest of the bill, I'm sorry to say that I do not think they provide strong enough safeguards. This is a well-drafted amendment that would tighten those safeguards, and I urge members to support it.
Danny Kruger.
Thank you very much, Madam Chair. I want to very quickly speak to Amendment 316 in the name of the member for York Central, who I think has tabled a very sensible suggestion that if a patient makes a statement after the second period of reflection, that there should be an automatic referral to palliative care. We've heard how expected and usual this is anyway, and the Honourable Lady has frequently made the point that people who are having an assisted death or going through the process are likely to be in palliative care anyway. It's not an either or. I think it's very important that we clarify that expectation, and it will obviously be the case that the patient is not required to take up this referral, and if that referral already exists, then that case is dealt with. But just to be absolutely clear that the decision to take an assisted death is not a fork in the road, as my concerns are. If that is not the case, that in fact palliative care and the assisted death process go hand in hand and will be seen as part of a sort of integrated package of support for patients, then my view is that we should specify very clearly that in the event of a decision to proceed down the road to an assisted death, a palliative care referral should be made. And bluntly, Madam Chair, I want to make it as clear as we can, and I'm not sure if we'll ever be able to do this fully, but it really has got to be very plain to healthcare commissioners and managers that there is to be no cost saving as a result of an assisted death referral. And I know that I very much doubt that a single commissioner or manager would have that at the forefront of their mind. Nevertheless, incentives apply in healthcare decisions. We ultimately have a ration system, and resource allocation necessarily is the job of commissioners. And if, as we're saying, a decision to proceed with an assisted death will be in parallel with palliative care, let's make that plain, so that if indeed it is the case that that patient requires the investment of palliative care services, of hospice treatment or otherwise, even though, as we know, hospice care is inadequately funded through public money, nevertheless, there is a resource requirement. I think it is important that we specify to everybody in the system that an assisted death is not a way of avoiding the expense of proper end-of-life care. So I hope that members will recognise that this amendment is consistent with the arguments that have been consistently made by advocates of the bill, which is that there's not an either-or between palliative care and assisted death, and in fact it's appropriate for patients to be on both tracks simultaneously. Thank you.
Minister.
Thank you very much, Chair, and it's a pleasure to serve under your chairship this morning. Chair, the purpose of Amendment 457 is to exclude a person who has less than 1 month to live from being eligible for the shorter second period of reflection of 48 hours, if that person has voluntarily stopped eating and drinking. That person would instead be required to comply with a second period of reflection of 14 days, in line with clause 13(2)(a). As drafted, this amendment could create uncertainty as to the required length of the period of reflection. It is unclear, for example, if voluntarily would include where someone's appetite has naturally declined as they approach the end of life, and therefore whose decision to stop eating or drinking may not be deliberate. Amendment 471, as I've previously said, the Government has worked with the Honourable Member for Spen Valley on certain amendments to bolster the legal and workability sides of the bill. And the purpose of this amendment is to clarify that the coordinating doctor needs to be satisfied that the criteria set out at subsection 4 are met immediately before witnessing the second declaration and not any time before. This also ensures consistency with the duty on the coordinating doctor in respect of the first declaration as set out in clause 6(3)(a). Turning to Amendment 316, this requires that where the coordinating doctor reasonably believes that the person seeking assistance has less than 1 month to live from the court declaration, they must refer the person for urgent specialist palliative care. As the referral must be made whether the patient wants that referral or not, this may result in unwanted referrals. The effect of this amendment is unclear. As currently drafted, clause 13(2)(b) sets out that where the person's death is likely to occur within 1 month, the period of reflection is then 48 hours. This amendment sets out that the referral to urgent palliative care must be made alongside the coordinating doctor making the statement, which is the last step to be completed before the provision of assistance under clause 18. So in some circumstances there may be insufficient time to make a referral before the person is provided with assistance to end their life. Turning to 374, this requires...
Just to emphasise, it's also the point, to make the point that at the moment the patient reaches that point, they will have had their palliative care options explained to them extensively as part of the bill. And it's highly unlikely at that point, as the Honourable Member for East Wiltshire says, that anybody would not be in receipt of palliative care, given the very late stage of their disease.
Well, I thank the Honourable Member for that intervention. I actually happened to be at a hospice yesterday on a ministerial visit in Stafford and was extremely impressed by the work that they were doing in that hospice in terms of family counselling, in terms of the advice and engagement both with the patient and family and loved ones. So he's right that the hospice sector, amongst others, play a vitally important role in that holistic engagement with patients throughout the process. On 374, this requires that the coordinating doctor must notify the voluntary assisted dying commissioner where they witness a second declaration and where they make or refuse to make the supporting statement under subsection 5 of clause 13. The commissioner must be provided with a copy of the second declaration and any statement. I hope that those observations were helpful to the committee. Thank you, Chair.
Kim Ledbetter.
Thank you, Chair, and it's a pleasure to serve under you this morning. Chair, I'll speak briefly to my amendments 374 and 471. These amendments serve first to clarify that the second declaration must be made before it is witnessed, a drafting amendment, and then to bring clause 13 in line with the reporting requirements elsewhere in the bill. For the functions of the Commissioner to be carried out effectively, including supervising the assisted dying panels and making annual reports on the operation of the legislation, it's essential that all relevant details and reports are made available. With regard to Amendment 457, I'm unable to support this amendment in the name of the Honourable Member for Richmond Park. As I said when we started discussing the amendment, I don't fully understand why it's been positioned at this stage in the process. The shorter period of reflection is a recognition that a person's death is expected within a month, so they are literally a few weeks left from their life.
Sarah.
Thank you, Chair. I just on that was the response she gave when I made my speech on this in the previous session. I've been reflecting on that over the weekend. I still think that the issue of voluntary stopping of eating and drinking is a very, very serious issue that ought to be reflected somewhere in the legislation. But I think she is correct that at this particular point we're talking about the second period of reflection already being at an end, and therefore can't be hastened in any way by this particular thing. So I will be withdrawing that amendment. Thank you.
I appreciate that. That's really helpful. Thank you so much. And I think, as the Minister has said, there are a number of reasons why a person whose death is approaching may have stopped eating and drinking. They may simply just be too ill. They may be unable to digest food. It may be that they've lost their appetite, or that they're even more ill if they do eat and drink. So it would seem particularly cruel to intervene on this basis at that point. But I appreciate the comments that the Honourable Lady has said. Regarding Amendment 316 in the name of the Honourable Member for York Central, this seeks to mandate the action a doctor must take if a patient is likely to die within 1 month. Like other amendments, it kind of goes against the basic principles that underlie the bill, that the wishes of the person seeking assistance should be respected. And surely this is even more important than ever as they face their final weeks. As the Honourable Member for North West Hampshire said, palliative care have been discussed at length throughout the assisted dying process. And it's also worth noting, as the Honourable Member for East Wiltshire has said, that evidence from other jurisdictions with similar laws, Australia and America, shows that between 80% and 90% of people who have gone through the assisted dying process are actually already receiving palliative care. So I'm not minded to support this amendment. Thank you, Chair.
Sarah Olney.
I'd like to withdraw my amendment 457, Chair. Thank you.
Is everyone content for the amendment to be withdrawn?
Aye.
Amendment by leave withdrawn. We now come to Amendment 314 to Clause 13, which has already been debated with Amendment 301. Does any member wish to move that amendment formally? Amendment withdrawn. We now come to Amendment 315 to Clause 13, which has already been debated with Amendment 301. Does any member wish to move that amendment formally? Amendment withdrawn. We now come to Amendment 207 to Clause 13, which has already been debated with Amendment 184. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 207 to clause 13 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 470 to clause 13, which has already been debated with Amendment 369. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 470 to clause 13 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 471 to clause 13, which has already been debated with Amendment 457. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 471 to clause 13 is on the amendment paper. The question is that the amendment be made. As many of the opinions say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 316 to clause 13, which has already been debated with Amendment 457. Does any member wish to move the amendment formally? They do not. We now come to Amendment 208 to clause 13, which has already been debated with Amendment 184. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 208 to clause 13 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 472 to clause 13, which has already been debated with Amendment 469. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 472 to clause 13 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 374 to clause 13, which has already been debated with Amendment 457. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 374 to clause 13 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 13, as amended, stand part. The question is that clause 13 stand part of the bill. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 375 to clause 14 in the name of Kim Ledbetter, which with it will be convenient to consider Amendment 376 and clause 14 stand part. I call Kim Ledbetter to move Amendment 375.
Thank you, Chair. Hopefully a couple of nice, simple ones here. Chair, the right of the patient to cancel at any time is obviously really important. It's also important that for the purpose of monitoring and reporting the process, the Commissioner, as proposed, is kept informed at every stage. So I hope all members of the committee can see the necessity for these amendments, and I move that they stand part.
Amendment 375 to clause 14 as on the amendment paper. The question is that the amendment be made. Danny Kruger.
Thank you, Chair. The Honourable Lady is quite right. Nothing to object to in these amendments, or this clause. The important thing, though, that I think it is worth stating at this point is, in the context of the debate that we are having in this committee, we are moving at some pace. The likelihood is there will only be an opportunity for a 5-hour debate at report stage, maybe more, but possibly not. This committee is the time we have to consider in detail the content of the bill, and my concern is that moving too quickly and trying to do too much too soon means that we will miss the opportunity to debate very important aspects of the bill. And the Honourable Lady says that these are nice, simple amendments, as if the only thing that's being discussed here is the paperwork around the declaration. I wonder what we should be saying to patients who do decide to cancel their declaration. And my concern is, so far, and I'm unaware at what other point we can appropriately discuss this question. What does happen in the event of a cancellation? What is the duty of care that doctors have to their patients if they have decided not to proceed with the assisted death? The bill currently does not address that question. It imposes no obligation on doctors to follow up in any way after a declaration has been cancelled. And as ever, I absolutely agree, as honourable members will no doubt be thinking in response, doctors have a duty of care to patients, and absolutely they do. Nevertheless, we are talking about a new procedure that sits in this uncomfortable hybrid state between healthcare and non-healthcare. We have special rules and procedures around this particular intervention that is being designed here, and we are still ignorant about the precise mechanisms by which healthcare professionals and potentially others will be involved in the administration of this process. And so what exactly happens in the event of a cancellation? I think it's worth at least understanding, perhaps from the sponsor, what her understanding is, what the expectation should be upon the providers who have been responsible for supporting the patient up to that point. I mean, if the amendment that I spoke to in the last clause had been accepted, whereby a palliative care referral is automatically made, I will give way in one moment, then we could have some reassurance that other doctors were there to pick the patient up. But I just want to, before I give way to my right honourable friend, I just want to posit the hypothesis of a private provider which has been established explicitly for the purpose of facilitating the assisted death procedure for patients. If they step back at the point that the patient decides to cancel their declaration, they're required to notify the GP as soon as practicable, whatever that means. The time frame there is clearly at the convenience of the provider, not of the patient. So my concern is what happens when the patient's GP is not quickly informed that they've decided not to proceed with the assisted death, and they are sitting there in a limbo. Obviously, there's significant concerns about their well-being given their decision, given the state they're in. And I'm not fully clear yet what the obligations on the doctors would be at that stage. Does my right honourable friend want to come in?
Grateful, Madam Chair. I'm not entirely certain that his remarks are germane to the amendments, but nevertheless, as we discussed in the last grouping or the last clause, at the stage he's talking about, the patient will have had all of their options explained to them. And will have had everything that is available to them explained to them, and everything which the health service, as we said, all appropriate, I think we've amended the bill to say, services that will be available to them. So if they are cancelling, the presumption has to be, in respecting their autonomy, that they're choosing one of these alternative paths that has been laid available to them. It's quite hard to legislate for a negative.
Danny Kruger.
I'm grateful, Madam Chair, and I'm speaking to the clause as a whole. The stand part debate is part of this grouping, so and I've got no objection to the amendments. My right honourable friend is absolutely right, and as I've said, the expectation is that the medical professionals involved in the person's care will have laid out their options clearly. We are to a certain degree trusting in that, because amendments to insist on that have been rejected, although I recognise that will be the clear expectation. And he is right that it is hard to, as it were, prove a negative. Nevertheless, the purpose of my intervention at this point is to tease out from the advocates of the bill what their expectation is. And I think my right honourable friend has just clearly explained his expectation, which is that we're dealing with somebody in the fullness of their autonomy, absolutely unfazed, their mind uncluttered by other concerns, clear, rational, and entirely free of any undue influences or any particular anxieties about the different choices they might make. In the fullness of their autonomy, they've decided, having previously decided in the fullness of their autonomy, they wanted to go through this procedure. Now, in the fullness of their autonomy, they're deciding the opposite. And we should say, fine, we have no further interest in your decision-making. It is your choice. You're on your own. I'm very concerned about the implication that the right honourable gentleman has about the sorts of patients that might, in fact, be involved in the process of assisted dying. Happy to give way.
Just maybe to allay those fears, I think the fundamental question, the fundamental answer to the question is that if they don't stop being patients, sadly, they don't stop being terminally ill patients. They've just chosen to cancel the declaration. So the wraparound care that is already there with them. And he's answered his own question to some degree, Chair, in that you said doctors have got a duty of care. That duty of care doesn't stop because the person's chosen to take this course of action. They will still be cared for as they would by the professionals who will be looking after them.
Danny Kruger.
I'm grateful. Well, we'll certainly hope so. Nevertheless, that is inconsistent with the doctrine of absolute patient autonomy, which has allowed a patient in this circumstance to withdraw from the medical treatment, or at least the support of medics who have been facilitating their assisted death. It is not, they're under no obligation, rightly, to receive any other sort of care. And of course, in most cases, one will absolutely assume that there will be medics closely involved in looking after them. They're likely to be very ill. Nevertheless, if the expectation is that the bill has nothing more to say and the medics involved have nothing more to say and no further obligation to ensure that a patient who has just stepped back from the brink of suicide will be looked after, except that they're in the fullness of time, as soon as it's practicable for the provider who's just been denied the business of looking after their assisted death, as soon as they can get round to sending an email to the GP. If that is seen as sufficient to ensure that this patient will be properly looked after, I beg to differ. Happy to give way.
I'm not sure what compulsion there is in wider legislation for there to be duty of care to patients who don't choose assisted dying in the first place. Right? We have thousands and thousands of patients who die for whom there's no legislation that compels certain duties on medics or otherwise to look after them. We rely on the professional standards and the overall atmosphere of the healthcare to care for them as they would for these people. And just finally, I'm just say, as he knows, there's, from overseas experience, there's a large proportion, up to a third of people who obtain the right for assisted dying, who in the end do not cancel, but do not exercise it, because as we've said before, assisted dying for so many people is an insurance card that they may choose to use if and when they think their life becomes intolerable.
Danny Kruger.
I'm grateful. I recognise that. That's not germane to the debate that we're having, which is about the event of actual cancellation. And I think the question does arise, why has there been a cancellation? He's absolutely right. There is no obligation to proceed once you pass each particular hurdle, and many won't. But those who decide actively to renounce their decision, I think a big question should then be asked, what's going on and what help is further needed? And my right honourable friend suggests that we don't step in and ensure that care is provided or have any additional obligation in the event of patients in other circumstances. As ever, he has, I'm afraid to say, a coldly rationalistic vision of both healthcare and the sorts of patients that we are dealing with, who will be, as I've said to him, acting much as I imagine he would imagine himself acting in that circumstance, I think from a position of health and self-confidence. In fact, we're dealing with people who are, by definition, in some turmoil. I mean, almost certainly in some turmoil if they've decided to renounce their decision to proceed. I crave the indulgence of the committee because I'm talking at length about a set of amendments I don't propose to oppose, and I recognise the value of the necessity of the clause in this in the bill here. But I do want to just put it on the committee's mind that we are not simply dealing with a bit of paperwork here. We are dealing with a human being who has made having made one enormous decision to die, is now making an enormous decision to live, and we're treating it as if it's a sort of bureaucratic question only. I'll just finish with a question to perhaps the Honourable Lady or to the Minister, just to help me understand something that confuses me in the clause here. I'm happy to give way first.
Nice. Sean.
Thank the Honourable Member for giving way. And whilst he was talking, because I've not given it as much thought as he has, but whilst he was talking, it would, for me, there is a concern, because my interest is very much domestic violence. Would he agree with me that it could be somebody who has experienced domestic violence, or children could be at risk, and they've then decided not to take the option, even though they wanted to, because of obligations elsewhere?
Danny Kruger.
I'm very grateful. I mean, she is indeed right, and it does go to the debate that sort of runs through all of these clauses, which is the question of why. And we rejected as a committee the obligation on the doctors to ask that question: why are you doing this? Because it was suggested by one honourable member that it was none of anybody's business why somebody should be trying to take their own life, and if they qualify, they should be able to summon the agents of the state to provide them with lethal drugs without any question about their motivation. As the Honourable Lady says, I think there is an equal expectation in my mind, and I would expect doctors to be asking this question, why are you changing your mind? And therefore, and it's something that could be clarified in this clause, what further referrals would need to be made, if they're not already, because as we've acknowledged, we would expect appropriate care to be provided by doctors anyway. Just to conclude with my sort of factual question, as it were, I am unclear. Subsection 1 of the clause lets the patient cancel a first or second declaration, but subsection 4 only says that the duties of the doctor stops when a first declaration is cancelled. So what happens if they cancel a second declaration? I'd be grateful if the sponsor could explain what happens at that point. I mean, it does strike me that there would be a need for some urgency at that point if a second declaration is cancelled. It's arguably a more dangerous situation if a patient at that point is deciding to change their mind. And what are indeed the obligations on the doctor at that point? Should we just read across from subsection 4 that the duties stop in the same way? Perhaps that could be clarified in later drafting if necessary. So just to conclude, Madam Chair, my general point here is that the issue of a council declaration is about more than the paperwork. And while, of course, we respect the autonomy of patients to make their own decisions in this regard, to cancel a declaration, of course, and it's a right that I would obviously insist that is there. Nevertheless, it does raise the question in my mind, why is that happening? And what should we expect their medical team or others to do in that circumstance? Thank you.
Minister.
Thank you very much, Chair. These are amendments 375 and 376 that the Government has worked with the Honourable Member for Spen Valley on. These amendments require that where the coordinating doctor or any registered practitioner with the person's GP practice receives a notification or indication from the person seeking assistance under the bill that they wish to cancel their first or second declaration, they must inform the Voluntary Assisted Dying Commissioner as soon as practicable. Where a registered practitioner with the person's GP practice has received a notification or indication from the person to cancel their first or second declaration, they must also inform the coordinating doctor. I hope those observations are helpful to the committee. Thank you, Chair.
Kim Ledbetter.
Thank you, Chair. Just to conclude, and I think I'll repeat what I said earlier on in terms of what will happen to the patient if they choose to cancel. I think their care will continue. I think it's inconceivable from a medical practitioner perspective that those patients would just be abandoned, as he's suggested. That just wouldn't happen. In terms of cancelling the second declaration, my understanding is that in terms of the time of when that would happen, it wouldn't need to be included in subsection 4 because we're further down the process. So the first declaration comes much earlier on, so sections 7 to 9 would be applicable, but I think the second declaration comes further down the process, so it wouldn't need to be included in that. But I'm happy to have a look in further detail and come back to it if needed. Thank you, Chair.
Amendment 375 to clause 14, as on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye. Aye. To the contrary, no. I think the ayes have it, the ayes have it. We now come to Amendment 376 to Clause 14, which has already been debated with Amendment 375. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 376 to Clause 14, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it, the ayes have it. We now come to the question that Clause 14, as amended, stand part. The question is that Clause 14 stand part of the bill. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it, the ayes have it. We now come to Amendment 321 to Clause 15, in the name of Daniel Francis, with which it will be convenient to consider Amendments 431, 473, 253 and Clause 15 stand part. I call Daniel Francis to move Amendment 321.
Thank you, Chair, and it's a pleasure to serve under your chairship, and with your permission I'll formally move Clause 321. So I move and will speak to Amendment 321 taking my name. This amendment will mean that in the proxy's declaration they must also include the reason why the person was unable to sign their name. This would add a vital safeguard for the person and also for the proxy. In this committee, we've consistently discussed the need to safeguard vulnerable people from being coerced into choosing assisted dying. And for those who need a proxy, the risk of coercion could be higher. In the bills it currently stands, the person needs to tell only their proxy the reason why they're needed. I'd like to make it clear why it's important to add this amendment. The bill does not currently specify that the patient's declaration of the reason for needing a proxy has to be heard by anyone other than the proxy themselves. And clearly, since my amendment's tabled, I'm obviously conscious the sponsor has also put amendments down to change the relationship who the proxy could be. But I don't believe that my amendment would be a burden or cause any unnecessary complication. Under the bills it currently stands, when a proxy signs a declaration, they already have to include their full name and address, the capacity in which they qualify, and a statement as to that they've signed in the capacity as proxy. As we said before, it's vital to safeguard vulnerable people every stage of the process, and adding the reason why the proxy was required allows other people during the process, and clearly if there were allegations later, to understand why that was required. If the first declaration is signed by a proxy, then the coordinating doctor, the independent doctor, would be able to examine that reason and understanding, including the reason for being able to sign your own declaration would improve the transparency around the process. I hope honourable members will agree that we need to be able to monitor how those requests are made and the reasons that people are giving. Several experts in their written evidence raise the importance of collecting good data in order to ensure the assisted dying process is properly monitored, and this would assist that. I believe the amendment will protect both vulnerable patients and proxies. And as I've already said, the reason I tabled this amendment was mainly, I absolutely appreciate and understand that people may have a very good reason why they require a proxy if they are very ill and in that process, but it would simply mean that if there were to be concerns or allegations at a later stage, then the reason would be written down why that proxy was required.
Thank you, Chair. And I think he's making a really sensible point and a really fair argument. I'm very happy to support the amendment.
Well, I welcome the sponsor accepting the amendment, and I think she sees the point why that the amendment was made. It was simply, not to be awkward, I don't think I've been awkward during the process at all, but simply to state, if there were concerns later, that was there in a transparent way. Thank you, Chair, and I will move in due course my amendment 321.
Danny Kruger.
Thank you. Just quickly, I'm grateful to the honourable gentleman and very much support his amendment. It's very good to hear that the sponsor will as well. Just to quickly speak to these amendments, you've made the point there very powerfully, and it's good that we're in agreement. To the amendment in the name of the member for York Central that would restrict proxies to donees of lasting power of attorney, I would support that amendment too. The point is that somebody who's been through a process of becoming a power of attorney has been properly vetted and approved. They are required to demonstrate their fitness for the role and undertake a meaningful duty of care to the person that they are proxy for. And it strikes me as an appropriate suggestion made by the Honourable Lady. To Amendment 411 in the name of the member for Broxtowe, which suggests that the phrase "a person of good standing in the community" is deleted. I think she's absolutely right to suggest that, as I made the point in this second reading debate. I think she's about to say that her own amendment addresses that point.
That was withdrawn. That was the point.
Is that the case? I apologise.
I'll double check.
Okay, I'm grateful to the Honourable Lady, if so. I regret it because I think it was a good suggestion. My preference would have been if we were to amend this rather than removing the whole question of a proxy, which might be the safest thing. Nevertheless, if we're proceeding with a proxy arrangement, it does strike me as dangerous to have included the opportunity for a member of good person of good standing in the community, which while it sounds sort of old-fashioned and sort of sonorous expression as if it has genuine meaning and recognition, I don't think it is an acknowledged concept and doesn't appear in English law much, if at all, and obviously begs the question, what on earth does it mean? And who is to determine who is of good standing? I labour this point, even though the amendment might have been withdrawn, because the amendment in the name of the Honourable Lady, 473, which proposes to delete that phrase and, in fact, delete the whole point about who the proxies could be, and simply gives that responsibility to the Secretary of State. This, Madam Chair, is another, I think, very important indication of a running flaw in the bill, which is, and particularly in the amendments that have been laid in committee, which is to transfer important decisions beyond this committee, beyond Parliament itself, to the government, to the Minister of the Day. And this matters because we are here trying to ensure that this bill, when it passes, if it passes, is a safe one. And we have here just a blank space being left in this important question of who can determine who the proxies are. The proxies have enormous power to do the paperwork, to answer the questions, to act essentially on behalf of the patient who in the scenario envisaged, would be silent. So who the proxy is matters. The decision of the Honourable Lady is not to resolve that question here in the committee, but to pass that on to a future minister. And my concern is that exactly the same ambiguity or openness that is in the current bill, which is a person of good standing, this serious sounding but actually vacuous concept, could simply be replicated in the regulations specified by the Secretary of State. So I am worried about where we're going here, and I wish we could have instead amendments that would either restrict the proxy to somebody known to the patient without the person of good standing, or if we're to do without that phrase and imagine that there will be other criteria, other individuals who would be judged appropriate to be the proxy, that we had the will to do that now. It might well be that the Honourable Lady working with government have concluded they didn't have enough time to come up with the list or to think through the various complications involved in deciding who the proxy should be. Again, I regret the pace at which we're moving, if that is in fact the decision. I don't see why this is something that has to be delayed until the Secretary of State can come up with a plan in a couple of years' time. Why this question isn't being resolved now on the face of the bill. Thank you.
I can confirm that the Amendment 411 has been withdrawn. I can't see any other members bobbing. Minister.
Thank you very much, Chair. On 321, this amendment would require a proxy to record when signing the declaration on behalf of the person the reason why the person they're acting as a proxy for is unable to sign their own name. The recording of the reason may make the use of a proxy more transparent. It may also assist others involved in the scrutiny of the process to understand why a proxy was used. 431 seeks to restrict who can be a proxy under the bill to attorneys in a lasting power of attorney, or LPA, for health and welfare decisions. That is, those people who are able to consent to or refuse life-sustaining treatment. This raises significant practical issues. First, not everyone has an LPA. Second, where a person has made an LPA, they will have decided whether to give the attorney the authority to refuse or consent to life-sustaining treatment. This is not automatic and means not all attorneys would be able to meet the eligibility requirement of this amendment. Third, the Mental Capacity Act only enables an attorney to exercise power under an LPA if and when someone has lost capacity.
Would he also agree to me that, unfortunately, my honourable friend from East Wiltshire seems to be labouring under a misapprehension that there is some reputational test in becoming an attorney. In truth, I can appoint anybody I want to be my attorney, and there's no verification or otherwise until there's some form of dispute around the exercise of the power of the attorney. And in fact, actually, the regulations may mean that we have a stronger sense of verification of the bona fides of the person who is a proxy than we would do through the LPA route. Also, doesn't he find it slightly sad that given the type of Conservative that I know my honourable friend is, he thinks that the concept of being in good standing in society is somehow meaningless.
Minister.
I thank the honourable gentleman for that intervention. I am not a lawyer. Thankfully, I'm sitting next to a very eminent and distinguished lawyer who has confirmed that everything the honourable gentleman just said was correct from a legal standpoint. So I will leave it at that. On Amendment 473, clause 15.5 of the bill defines a proxy as a person who has known the person making the declaration personally for at least 2 years, or B, a person who is of good standing in the community. This amendment would remove subsection B, namely a person who is of good standing in the community, from the definition of proxy in clause 15.5. Instead, the amendment would introduce a regulation making power to specify the persons who may act as a proxy in regulations. This would avoid any ambiguity around the meaning of person who is of good standing in the community and retain flexibility to amend the specified list in regulations.
Would you give way?
I will give.
Danny Kruger.
I'm very grateful. Will he confirm that the Secretary of State could simply reintroduce this ambiguous term at their own discretion? If the freedom is being left to the Secretary of State to decide who can be a proxy, the decision might be then made that it should be a term of equal ambiguity. And while my friend is absolutely right, I have great respect for the concept of standing. Nevertheless, I don't believe that the government has yet been able to define exactly what that means. So there is still, just agree with me, there still is the opportunity for ambiguity. We're just leaving it completely blank at this stage and hoping that some future Secretary of State will have more clarity than we do.
Well, I thank him
Minister.
for that intervention. I wouldn't want to preempt the regulations because clearly that's the point of the process. Is if this bill gets royal assent, you then move on to making regulations, and I am confident that through the good offices of Parliamentary Council, through the legal advice, through the process of drafting regulations, absolutely I agree with him that the purpose of those regulations must be to remove ambiguity, not to increase ambiguity. So I'm confident that the system will produce regulations that address the concern that he's just raised.
Would he go on that point?
Kim Ledbetter.
Thank you, Chair. And would the Minister agree with me that actually it will be on the record that we've had this conversation and many of us, including myself, have expressed our concerns about the concept of good standing in the community, and I'd like to think that that would be taken into consideration as well.
Minister.
I thank my honourable friend for that intervention. I am acutely conscious of the fact that every word that we say in this committee is on the record, and she makes a valid point in that context. So this amendment would, 253. The purpose of this amendment is to clarify that a person acting as a proxy can both sign and revoke a declaration on behalf of a person seeking assistance under the bill. This amendment would extend the provisions under clause 15 to a person who is acting as a proxy to the person seeking assistance under the bill. This would enable the proxy to act on behalf of the person to cancel their first or second declaration if they are unable to sign their own name by reason of physical impairment, being unable to read, or any other reason. I would note that the cancellation of a declaration is governed by clause 14, and the cancellation may be given orally, via writing, or in a manner of communication known to be used by the person. It does not require the signature of the person seeking assistance under the bill. So a proxy may not be required for some people in relation to revoking the declaration, even if they have required a proxy under clause 15. Oh, sorry, yes.
Now,
I thank the Minister for giving way. Just on the point of the sponsoring member, I just want to understand, should the issue of proxy end up before a court, which bit will they rely on? Will they rely on the conversation we're having here and the intentions made during this bill committee, or will they rely upon a future SI or what the Secretary of State puts in the guidance, just for clarification?
Minister.
Well, the regulations will have primacy. The regulations will be shaped by a range of inputs, including the conversation we've just had here in committee. But the process will be, bill gets royal assent, regulations get drawn up based on a range of consultation and input, including the Hansard, and the regulations then become the basis on which this proxy process is is managed and dealt with and enforced and executed.
Just on that point.
Now, Sean.
I thank the Minister. I just genuinely want to understand this. So what if the regulations, even though we've had this conversation in this committee, what if the Secretary of State, following those consultations, decides otherwise? Then what recourse do we as a committee have in terms of challenging that?
But
Minister.
The bill, once it becomes an act, places a legal duty on the Secretary of State to produce those regulations. So the Secretary of State would be in breach of the law if he were to not enforce the conclusions of the bill, which would have been an act by then. Thank you, Chair. That's it for in terms of my observations. I hope they were helpful.
Kim Ledbetter.
Thank you, Chair. I'll speak first to my amendments 473. And I think it's really important to be clear that the role of the proxy is very specific and would only be used in a very limited number of cases where the patient is not able to sign their own name. But that is important when we're talking about terminally ill people who may be physically impaired, as the honourable member to my right alluded to.
Will she give way?
Of course.
I'm very sorry to interrupt so quickly in her speech. Nevertheless, the clause says that they're unable to sign the name of physical impairment, as she said, being unable to read, or for any other reason. I mean, does she acknowledge that that's tantamount to saying that somebody can be a proxy? Somebody can have a proxy for any reason at all. I mean, there is literally no restriction in the clause on the reason somebody could have a proxy, so anybody could have a proxy.
And I think, thank you, Jan. I think that's why the amendment from the honourable member to my right is really important, that we have to put the reason down as to why there is a proxy. I mean, it does depend on personal circumstances and it does depend on what that patient is going through, so I think we have to have a little bit of flexibility there. But they've got to be unable to sign their name. That's the point, and they have to explain why they're unable to sign their name. Yeah, sure.
Danny,
sorry, I hope this doesn't feel pedantic, but we are talking about life and death after all. So the inability to sign the name could be psychological. It's not as if they're going to have to do a writing test, I presume. They simply have to say that they're unable to sign their name, unless she's proposing that there could be some sort of test for that. And to the point about the honourable member's amendment, which I entirely support, about being obliged to state the reason why, and it's very good, finally, in this bill to have the question why being asked. Nevertheless, there's no obligation on anything to be done about the reason why. They could give a reason why which would be regarded as irrelevant. So I respect the intentions behind the amendment, but it doesn't clarify this point that literally anybody could effectively get a proxy to sign their name, could say to the authority, to the assessing doctor, I want my friend to sign for me.
And I think this is the sort of thing the doctor would explore with the patient. I do think we have to be clear. It's going to be a very limited set of circumstances where this would happen. And I think, but we have to accommodate people who are physically impaired as a result of their terminal illness, and I think we have to include that there are a range of circumstances where this might apply. The proxy is not being asked to make any kind of judgment or assessment, but merely to act as an intermediary for the patient if they're unable to sign for themselves. And they would have to explain why they're unable to sign for themselves. And that proxy does have to be satisfied that the person understands the nature and effect of the making of the declaration. And I've thought long and hard about who should and should not be accepted as a proxy. And as always, I try to imagine how this would be seen by someone with a terminal illness. And as we know, no two people are the same, nor are their circumstances. The honourable gentleman referred to, surely this should be done by someone the patient knows. And obviously within the clause, it does talk about someone they've known for 2 years. So that is an important inclusion as well when it comes to the role of the proxy. But not everyone might have known someone for 2 years who they're comfortable with asking to undertake this role. But I also really appreciate the challenges of the word in good standing in the community. I'll let you two fight that out amongst yourselves. But I'm sure we've all got our own version of what that means. And I've explored various options, and contrary to the suggestion from the member for East Wiltshire, I've spent a huge amount of time on this actually because it is very important. Looking at different lists, we've got the list of people who can sign the back of your passport. I don't think that would be appropriate, so I've moved away from that. I've looked at much shorter lists, and I do think this is something which would take place as part of a consultation, and I think it's really important to get this right, and that's why I think we have to have it as part of the consultation, and that's why I'm content that putting this in regulations with the Secretary of State is the right thing to do. Chair, as I've said, I'm very happy to support Amendment 321 in the name of the Honourable Member for Bexley Heath and Crayford. It's a very sensible amendment which makes the reasons for the use of the proxy more transparent, and as such I'm very happy to support it. If the Amendment 253 is moved, I'm very happy to support this amendment as well, in the name of the Honourable Member for Filton and Bradley Stoke. As has been said by the Minister, a cancellation need not be in writing. It can be made orally or in any other form of communication, but I would be happy to support this amendment. Thank you, Chair.
Daniel Francis.
I beg to move the amendment in my name, Chair.
Amendment 321 to clause 15. As on the amendment paper, the question is the amendment be made. As many as of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 431 to clause 15, which has already been debated with Amendment 321. Does any member wish to move the amendment formally? They do not. We now come to Amendment 473 to clause 15, which has already been debated with Amendment 321. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 473 to clause 15, as on the amendment paper. The question is the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 253 to clause 15, which has already been debated with Amendment 321. Does any member wish to move the amendment formally? Sean Woodcock. Amendment 253 to clause 15, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 15, as amended, stand part. The question is that clause 15 stand part of the bill. As many as that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 209 to clause 16, which has already been debated with Amendment 184. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 209 to clause 16, as on the amendment paper. The question is the amendment be made. As many as of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 377 to clause 16, which has already been debated with clause 12 stand part. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 377 to clause 16, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 474 to clause 16, in the name of Kim Ledbetter, with which it will be convenient to consider amendments 475, 476, 477, 478 and clause 16 stand part. I call Kim Ledbetter to move Amendment 474.
Thank you, Chair. These amendments are designed to streamline the drafting of the bill. Taken together, to create a new definition of a recordable event, namely those set out in clause 16, subsection 1, where declarations and statements are required at any stage in the process. Record keeping is something I believe we can all agree is essential, and so defining those events that should be recorded is needed. So I beg to move these amendments and let the clause stand part.
Anybody wish to speak? Danny Kruger.
Sorry. Thank you, Chair. Very much respect the intention of the Honourable Lady here and very happy to support the amendments. Just to the stand part debate, nevertheless, I wanted to take the opportunity to express a certain concern quickly about the way that subsection 16(1)(b) requires the fact the coordinating doctor refuses to make a statement to be entered into the person's medical records, so that's good. But it does mean, as I understand it, a statement could therefore be made which complies with the bill but which does not put on record which requirements in subsection 2 the coordinating doctor did not believe were satisfied. So I think there is a lack of, there's an opportunity that we've missed to have more clarity about what exact requirements have not been met. And indeed, the eternal question of the reasons why. What are the reasons that the coordinating doctor reached that conclusion? I just note the opportunity missed to be a little safer with the drafting. But my general point to make, Madam Chair, is about the importance of effective record keeping and declaration. I really do thank the Honourable Lady. She has, throughout the whole process of this bill, stressed the importance of good data collection and good record keeping. And if this bill is to pass, it will be vital that we have that so that we can, in later years, judge whether the bill is working as intended or not. And my concern is that going on the evidence of other countries, which is frequently adduced in support of this bill, particularly the absence of evidence of coercion or questions around capacity or proper administration of the drugs, the support that patients receive. This is often referred, the point is often made that these concerns are exaggerated or inappropriate because look at what happens in other countries. Whereas, I'm going to quickly take the opportunity, Madam Chair, to briefly run through some of the evidence from abroad. The fact is, no other country does adequate record keeping. So, in one area where I really do share absolutely the ambition of the Honourable Lady, it is to have a better system of keeping data than other countries do, because here we go. In Oregon, the most recent annual report demonstrates a whole series of failures in record keeping. Ingestion status unknown for 25% of the patients prescribed the drug, so we don't know how they took the drugs, what the process was. In 72% of cases, it's unknown if there were complications. So we've been talking about how exaggerated mine and others members' concerns are about complications. We don't know in 72% of cases in Oregon. In 30% of cases, unknown if there was a healthcare provider present. 44% of cases, the duration between ingestion and death was unknown. And I recognise very much that the intention of this bill is not to have these sorts of mistakes, and indeed to specify that some of these that this should be impossible because the doctor should be present and so on. Nevertheless, it gives evidence of the fact that in other countries which have inspired this bill, the data is inadequate. Just a few more. In British Columbia, poor documentation, incomplete assessments, recurrent and excessive delays in reporting. I mean, we were just talking in the last group about the necessity of, if a declaration is cancelled, doctors should be informed. I'm very concerned that won't happen quickly and patients will fall through the gaps. That's what happens abroad. In Victoria, Australia, we've seen evidence from their former Attorney General, all sorts of irregularities, doctors falsely certifying patients had signed statements, and so on. Applications for... Happy to give way.
Thank you for giving way, and I thank you, Chair. I don't know the details of the individual cases he's speaking about, but I think he does make a powerful point, and we do absolutely agree on this, Chair, in terms of the importance of recording and monitoring. And I know the Honourable Member voted against the changes at Clause 12, but I hope he gets some reassurance from the changes that the Commission would bring in as a result of having the Commission, having the panels, that would ensure robust monitoring and reporting. And I hope he agrees that that is a positive step.
Thank you.
Danny Kruger.
Well, I am grateful, and I do absolutely recognise the Honourable Lady has every intention of insisting that the system works well, that doctors do their job, and that good record keeping happens. My concern throughout has been we haven't been robust enough about ensuring that all of that happens, and a huge amount of faith is being placed in the good professional conduct of doctors. And as I think I've said, the stress on patient autonomy often in fact translates into doctor autonomy. We are relying enormously on doctors doing their job well, and we're giving them significant latitude to do their job properly, in my view. And as we've seen from other jurisdictions, and particularly when assisted suicide becomes normalised, and indeed when services are established explicitly to provide assisted suicide, then we get into a dangerous area where adequate documentation and reporting might not happen. So, just to conclude with evidence from Canada, which is, again, a very comparable country. I know they have a slightly different mechanism for delivering assisted suicide, but their legal framework is very similar to ours. And we had evidence, the Health and Social Care Committee in the last Parliament had evidence from an academic there, Dr. Kotelik, who stated that federal regulations mandated the collection of data from MAID providers, just as we are going to in this bill. But the doctor goes on, those legal and regulatory efforts have yet to produce evidence that the programme operates as intended. We have no publicly accessible evidence that the eligibility criteria and safeguards prescribed by law were respected and that the criminal code has not been transgressed. So my general concern is that it's fine for us here in this committee and in Parliament to specify that all doctors should do their jobs properly and that all data should be appropriately collected and transmitted and recorded. Nevertheless, the reality, as we all know from our casework, is often of mistakes being made, bureaucratic mistakes being made, not with any ill will. And when we are dealing with the volumes that we may well be dealing with here, I think it is appropriate to raise significant concerns around the way that the bill will operate in terms of the data collection that we see. I'll leave it there.
So, Jan Joseph.
Thank you, Chair. I just want to talk about the record keeping in our healthcare systems. We have a huge issue in our healthcare system about record keeping. Huge number of coroner's cases, coroner's court reviews have identified record keeping in healthcare system have been an issue. So in this case, we're specifying the clinicians only need to record a recordable event and leaving this, the responsibility on the individual clinicians to decide what is a recordable event. It is very important that we have a good record is available to prevent incidents in the future and learn good practices as well. So leaving this open to just the clinician to record as a recordable event can leave that most of the issues are not getting recorded. For example, like if a clinician identify there was a coercion, and this is for the clinician to decide how much documentation they do. In my view, in my personal view, if they identify a coercion, then it should be recorded as an incident and further investigations should be done in those cases. In here, we're just leaving it up to the clinician to decide individual. With record keeping, there is no standard across the healthcare system. So in a care home, it could be different to in an NHS ward. So I think it will be for the committee or to look into in the future about what is this recordable event is actually mean. Thank you.
Minister.
Thank you, Chair. The purpose of these amendments, 474 to 478, is to improve the drafting of the bill by creating a new definition of a recordable event, which are the events set out in clause 16.1 related to the recording of declarations and statements. These amendments also make consequential changes to clause 16, which refer to the occurrence of the recordable event as per the new definition, and to include reference to a report in addition to a statement or declaration. The reference here to a report is consequential to the amendments already agreed by the committee to clauses 7 and 8. Thank you, Chair.
Kim Ledbetter.
Nothing further to add, Chair.
Amendment 474 to clause 16 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 475 to Clause 16, which has already been debated with Amendment 474. I call Kim Ledbetter to move the amendment formally.
Move forward, Chair.
Amendment 475 to Clause 16, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 476 to Clause 16, which has already been debated with Amendment 474. I call Kim Ledbetter to move the amendment formally.
Move forward, Chair.
Amendment 476 to Clause 16, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 477 to Clause 16, which has already been debated with Amendment 474. I call Kim Ledbetter to move the amendment formally.
Move forward, Chair.
Amendment 477 to clause 16, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 478 to clause 16, which has already been debated with Amendment 474. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 478 to clause 16, as on the amendment paper. The question is that the amendment be made. As many of those opinions say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 16, as amended, stand part. The question is that clause 16 stand part of the bill. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 479 to clause 17 in the name of Kim Ledbetter, which it will be convenient to consider clause 17 stand part. I call Kim Ledbetter to move Amendment 479.
Thank you, Chair. I think this amendment, which clarifies the drafting, speaks for itself. The important point is that the record of cancellation is with the GP practice as soon as practicable. It's not necessary that it takes place physically at the practice for this to be done as soon as practicable, as this could potentially delay its delivery.
Amendment 479 to clause 17, as on the amendment paper. The question is that the amendment be made. Minister.
Thank you, Chair. As currently drafted, clause 17(2) provides that where a notice or indication regarding a cancellation of a first or second declaration is given to a registered medical practitioner at the person's GP practice, that practitioner must record the cancellation in the person's medical records as soon as possible. This amendment seeks to clarify that requirement to record the cancellation, that the requirement to record the cancellation applies not just where the cancellation is given to a registered medical practitioner physically at the GP practice. It applies where the cancellation is given to a registered medical practitioner where the medical practitioner is with the person's GP practice, irrespective as to whether the notice was given at the GP practice. I hope that was helpful, Chair. Thank you.
Kim Ledbetter.
I'd beg to move the clause stand part.
Amendment 479 to clause 17, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 17, as amended, stand part. The question is that clause 17 stand part of the bill. As many of those opinions say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 378 to clause 18, which has already been debated with clause 12 stand part. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 378 to clause 18, as on the amendment paper. The question is that the amendment be made. As many of those opinions say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 462 to clause 18 in the name of Danny Kruger, with which it will be convenient to consider amendments 463, 497 and 498. I call Danny Kruger to move Amendment 462.
I'm very grateful, Madam Chair, Rose, to move that amendment and those in my name. And I think it's worth noting that this group actually, as it's worth, contains two subgroups. One is the first amendment in my name and those in the name of the Honourable Lady, which really concern the information that is given at the provision of assistance and decisions around that. And then my amendment 463 concerns this question about assistance itself in the final act. So I'll deal with those two separately. And it's, I think, worth noting, Madam Chair, it's a rather sombre moment in the bill because it's in this clause that the death happens, somewhere in here, in clause 18. I think somewhere between clause 18, subsection 9a, and 18, subsection 9a, Roman 1, between the self-administration and, I quote, the person has died. That's where it happens. And the debate onto these amendments is to make sure that we understand what is happening here and whether it's safe. And Amendment 462 in my name would require the doctor to make it clear to the patient at the moment of the final moment that they do not have to proceed. And of course this is clearly the implication of the bill. We've stressed autonomy all along, and everybody understands who's drafting this, helping us to draft this bill, all colleagues in the House, all doctors will understand, of course, the patient is not obliged to proceed at this point. But the reason for tabling this amendment is to think about the patient themselves, to put ourselves in the mind of the person who has gone a long way down this road, has summoned multiple professionals to endorse a decision that they have made, and we hope involve their family and other people in their life, all of whom will be aware of what is about to happen, one assumes, one hopes. And one also hopes supportive of that decision, or at least neutral about it. And for that person to find themselves suddenly at the moment when the drugs are due to be set up for self-administration, which is the point we're going to come to, that is the final opportunity that they have to decline to proceed. And throughout this bill, we have introduced, or the bill as it stands, as it's drafted, introduces hurdles, gateways through which a patient must proceed. In many respects, I don't think they are adequate, but it is obviously acknowledged by the framers of the bill that it is necessary to pass through certain hurdles, and in what might appear quite a formulaic way, to require the patient to confirm and to reconfirm that they have a settled and informed and clear settled and informed wish. What we don't have at this vital moment, in a sense the only moment that matters, because everything up to this point has been preliminary. At this point they step through the gateway, the final gateway. But there is no obligation currently in the bill, no expectation, no requirement for any conversation to take place. The doctor is expected to satisfy themselves. The doctor is expected to satisfy him or herself that the patient has a clear, settled and informed wish to end their life. And they must be prepared to swear to that. Nevertheless, there is no expectation that they will have a conversation, and we can pretend that, or we can imagine, we can hope, we can surmise that some kind of conversation would happen at that point. Do you want to proceed? Yes, I do. Nevertheless, we are not requiring it. And my reason for raising this, Madam Chair, is in the clear and certain knowledge that many people do at that moment have second thought. We know that from the numbers of people who contemplate and get very close to the act of suicide, unassisted suicide, and step back literally from the brink. I want to insist that there is an opportunity here to step back from the brink, just as our suicide prevention strategy seeks to ensure that the moment where many, and the places where many people tragically do take their own lives, on bridges, at Beachy Head, there are signs saying, call the Samaritans, or you are not alone. And to specify clearly that this is that moment, rather than having it assumed that the train has left the station and you're just on it now, I think would be a helpful amendment. I just want to quickly quote from a doctor that we had written evidence from, Dr. Philippa Youd, but she's writing in a personal capacity. I'll quickly quote from her. She says, I have witnessed post-euthanasia regret. I was 18 when my mother took her own life due to interminable suffering. She knew what she was doing. She had tried before. Just before she slipped into a coma, she told me she was sorry and that she regretted it. The inquest therefore deemed her death as an open verdict. It was suicide, but it was suicide that was regretted, despite true intent and interminable suffering, and no doubt capacity and a lack of coercion. No one can, she quote goes on, no one can ever be sure they want to die until the moment of death. They may still change their mind, and then it is too late. No one can know what patients will truly face emotionally and cognitively at the moment of death. I have witnessed firsthand the tragic circumstances of someone changing their mind after choosing to die. There is no peace in that. So I hope members will consider this amendment not as unnecessary embroidery or some kind of imposition on the autonomy of doctors or patients, just to require this simple statement to be made. You can still turn back and change your mind at this point. Happy to give way.
I thank him for giving way, and I think he's making a very powerful speech, and I thank him for the respectful way in which he's doing so. He's given an example there of a very personal story. I think it's also important to remember the other personal stories that we've all heard, and we do have family members who have lost loved ones with us today in the public gallery. Katie, whose mum went to Dignitas in Switzerland for an assisted death, and her daughter couldn't go with her. And as a family, they have suffered to this day as a result of that experience. So I think we also need to be really careful about the language you use, and we've spoken about this before, Chair, around suicide. You know, these cases that we've heard of, these are not people who want to die. They are people who want to live, but they are terminally ill. And I think we need to be really sensitive to that when we've heard so many examples of families who've been through these really difficult situations. But Chair, I think he also makes a very good point, and I am minded to support his amendment because I think it's coming from a good place.
Danny Kruger.
I'm very grateful to her, and I hear what she said, and we've had this conversation before. I'm afraid I do insist on my right to use the English language accurately, and what is being proposed in this bill is a carve-out of the Suicide Act. So I regret to say to the Honourable Lady, I will continue to describe this in terms that are appropriate to it. I hope I do so with absolute sympathy and respect for the many, many families who have suffered from the trauma of seeing their loved ones die badly, who would wish to have had an assisted death under the terms of this bill. I would say to the case the Honourable Lady mentions, and I'm very grateful to hear that she supports the amendment, I don't think it would be any sort of imposition on families for the doctor just to let them know at the last moment. They do have the opportunity to turn back. Happy to give way.
I'm very grateful for the Honourable Gentleman giving way. He's given a really powerful speech. I'm minded to support the amendment on the basis that there will be I regard it as a small but significant group of people who, having gone through all of this, will feel that they've been a burden on the people who have gone through all this effort through every stage to get to this end. And so I see it as and at that end they would be reluctant to, if they have those doubts, to maybe change their mind. I think it's a very small group, but I do think it's significant. I see it as a re-establishment of autonomy for the patient that we all believe in. Does the right Honourable Gentleman agree with me?
Danny Kruger.
Thank you. I'm very grateful to the Honourable Member, and that's absolutely right. We've just got to think about the no doubt quite turbulent emotions that people will be in as they approach the end of their life, and just to reiterate the opportunity that the genuine autonomy that they have. They are not on a conveyor belt that they can't get off until the very last moment, until they've passed through this gateway. And to remind them, and indeed their families, and I'm afraid we do hear terrible stories of people who have arranged their assisted death, and often family members have flown in from abroad. They've summoned doctors and so on, and then they feel that they have to proceed because, as the Honourable Gentleman says, they feel a burden as it is. They don't want to be an annoyance at the end by making everybody wait. So I'm afraid that is indeed the reason for it. So anyway, I'm very pleased to hear that it sounds like we're going to get that amendment accepted. I'm very grateful to members who will support it. Madam Chair, let me go on to the other more substantial amendment in my name in this group, which is Amendment 663, I think it is, to leave out paragraph C in clause 18. Sorry, I can't read my own writing. Thank you. Which will remove the subclause that says that the doctor can assist the patient to assist the person to ingest or otherwise self-administer the substance. And here we are in a lot of difficulty and grey area. So let me try and unpack the reasons for objecting to this subsection. The member for Spend Valley has argued that, I quote from her, from an interview she gave, a very clear line between the bills I am proposing and euthanasia, which is someone else doing the deed. The bill has to be the decision of the individual. The act has to be the decision of the individual, and it has to be the act of the individual. This creates that extra level of safeguards and protections. Now, I agree with her. I think it is right that we introduce this additional safeguard, which is to insist that the patient performs the act, the final act, themselves. I support this. I recognise there is a distinction between euthanasia and assisted suicide, and I support the attempt by the Honourable Lady to insist on that distinction in the law. It is another safeguard. But the fact is there is a blurred line between the two. And I can also understand why many people object to the exclusion of euthanasia, of physician-administered, or the fatal act being administered by other people. I mean, the doctor from Canada who said that it's inherently ableist to require the patient to self-administer, I think is unarguable. I mean, logically, if that is indeed the case, I think the logical provision would be to enable euthanasia if one believes in the autonomy of the patient. I'm afraid to say my strong belief is that the reason why euthanasia is not being proposed in this bill and by the campaign, which has been led by an organisation that used to call itself the Euthanasia Society, is because they have concluded that such a bill would not pass Parliament, because they think, I think correctly, that members of Parliament and members of the public would object to euthanasia. But the logic of the bill and of this campaign is actually for euthanasia, if one believes genuinely in autonomy and indeed in equal rights, and in not discriminating against people who are physically unable to perform the act themselves. Now, honourable members, despite my efforts, have not been able to conceptualise the difference between withdrawing a medical treatment which affects a particular medical condition, on the one hand, and administering drugs which annihilate the person on the other. I think there is a meaningful an important difference between those two things there. One is declining to use a shield, and the other is using a sword against yourself. So I think there's a difference there, and I regret that colleagues don't see it. But where I don't see a difference is between injecting yourself and asking someone else to inject you. Now, Madam Chair, there are two versions of the death of Saul in the Bible. And this is the only reference to the Bible I think I'm making in this whole debate. And I'm making it partly to show that there's in fact an inconsistency in the Bible. There's not a single biblical view of these matters. Anyway, in one account of the death of Saul, he's been defeated by the Philistines. He asks his servant to run him through with his sword, and the servant refuses. And so he falls on his own sword. He kills himself. In the other version, he gets a passing soldier to run him through, to kill him. Now, to me, it doesn't matter. These stories, the inconsistency in the story is interesting historically, but conceptually, logically, morally, I don't see the difference. Whether you fall on your own sword or you ask someone else to do it to you, it is still a sword. You are still actioning it. You are still responsible if you recognise that the individual has autonomy. But there is a practical difference. We're talking about assistance to die, about the role of another person. I will give way in a moment. We're talking about the assistance to die, about the role of another person who supports your decision and helps you to fulfil it. And I think, I'll give way in a moment, but this results in an obscuring of the practical difference. In actual practice, as we see here in section 6, the assistant comes very close to euthanasia. The role of the assistant, in my view, is closer to the soldier who kills Saul than the servant who refused to do it. Happy to give way.
I mean, he's making a really interesting philosophical point with his biblical references. I think the point he may be making is there might not be any difference for the individual, as the result is sadly the same, but I would put to him that there is actually quite a significant difference for the other person. And I think if we think about the autonomy of the medical professionals we're asking to be involved in this process, I think there's a strong argument to say that it would be very different for them to be more involved in the process. Does that make sense?
Danny Kruger.
I'm grateful. I really do thank you, because I think it's a very important consideration, and it's one that we haven't given perhaps enough attention to, which is the effect of this process on the medical professionals who will be involved. It's why we'll come on to the conscience clause in due course, but we've discussed it a little up till now. And yes, the Honourable Lady is absolutely right. There is a difference for the medics to the extent to which they are involved in the administration of the death. I'm afraid I don't see a major moral difference between providing the wherewithal and setting it up, and indeed helping the patients to ingest or otherwise self-administer the fatal drugs, and performing it themselves. I think the distinction is a very, very obscure one. I mean, there's a very significant grey area there. But to her point about as it were, giving appropriate consideration to the feelings of the medical professionals, well, if she believes in doctor autonomy, she should believe that doctors should have the autonomy to decide for themselves whether to perform euthanasia if euthanasia were legal, and that's what happens in other countries. In Canada, doctors can decline to take part, or they can participate. And it's worth noting, given the question of autonomy, in countries where euthanasia is legal, it is the overwhelming choice of the patients, as I think it would be for me if I were facing this terrible moment and this terrible choice. And we'll get onto the question of the drugs involved and the process of taking them in due course. But it's not a pleasant process, swallowing all of these pills. Far easier, more humane, less painful for a doctor to administer the drugs intravenously to you. And I visited Canada, and I met a doctor who's been responsible for over 300 deaths that she herself has performed, because that is the overwhelming choice of the patients. And she herself, I'm sure the Honourable Lady would agree, that doctor I referred to is acting in with full professional discretion and autonomy. So, going back to my point, I'm afraid this is one of these impossible dilemmas that the whole concept of assisted dying sets up, whether you allow the doctor to do it to you or not. And my concern is that if the stress on self-administration is genuine, it's not because, as I cynically believe, this is the only way to get it through the House of Commons. If it's genuinely felt that self-administration is necessary because the authors of the bill recognise the need to be absolutely sure that it's voluntary, and if that is the reason why we are insisting on self-administration, because we want to be sure that the act is voluntary, what does that say about all the so-called safeguards that exist up to this point, that we've been told are sufficient to ensure that we have absolute confidence that this is the person's clear, settled wish? If we are sure that people at this stage have a settled, informed, free wish to end their lives, why shouldn't they be able to ask a doctor to do it to them? The only answer to that question can be we don't actually genuinely believe that we are completely sure, and we want to make sure, as it were, in terms of our own moral propriety, sense of amour propre, that subsequent to the death, they did it themselves. It wasn't our choice. It wasn't us doing it to them. They did it. Happy to give way.
I'm a little confused by the Honourable Gentleman's logic. I mean, he's literally just proposed an amendment for the doctor to ask at the last whether the person still wants to proceed. And surely the self-administration is the kind of ultimate act of consent, which he himself has required in his own amendment, a doctor to establish right at the last moment.
Danny Kruger.
He's absolutely right. I do indeed. I support the distinction between self-administration and euthanasia. I am in favour of all possible safeguards, every possible opportunity to give the patient the chance to step back from the brink. The point I'm making is that I don't recognise the logic of the distinction which the bill insists upon. And indeed we see in the clauses that I'm concerned about, subsection 6, that distinction in fact doesn't really apply, because we are concerned, naturally enough, if we're believing in autonomy and if we're believing in giving people the opportunity for assisted suicide, then that should be available to people who cannot physically perform the act themselves. And I'm not trying to argue in favour of euthanasia. I'm saying we will get to euthanasia if we let this act go through. Because even in the bill, we're halfway there with subsection 6. And sure enough, in due course, I am very confident that the campaign will grow. In fact, it already exists. People are already objecting to the restrictions implied in the bill. The campaign will grow to widen the opportunity for assistance to ensure that we can have physician-administered suicide, as happens in Canada and elsewhere, very, very logically. So once we pass the Rubicon of assisted death, it is a straight road to euthanasia. I'm sorry, the honourable gentleman is amused. So let me unpick this a little further. There's clearly a problem with subsection 6 because you then have two further subsections which appear to sort of qualify it, sort of apologise for it, or make it clearer what's being said there, which is always dangerous drafting in a bill when you have a subsequent section that casts doubt on an earlier one. So subsection 7 says that, but, with a big red light suggesting that there's a problem, but the decision to self... This is after the subsection which says that the doctor can assist the person to ingest or otherwise self-administer. Then the next line is, but the decision to self-administer the approved substance and the final act of doing so must be taken by the person to whom the substance has been provided. And subsection 8 says that subsection 6, the one about assisting, does not authorise the coordinating doctor to administer an approved substance to another person with the intention of causing that person's death. So that's very helpful. I mean, that's what we thought the bill said anyway. I'm not quite clear what the purpose of subsection 7 and 8 is, except that there is inherent danger in subsection 6. And I'm afraid subsection 7 and 8 do not cancel the danger in subsection 6 because of the inherent lack of clarity, the blurring that exists in this concept of assisting that person to ingest or otherwise self-administer. So, happy to give way.
So, Joseph.
Thank you, Chair. Would the honourable member clarify? You're making a very valid point. I'm just thinking of sitting there and thinking about it. As a nurse, worked in many areas where a disabled person maybe not take the medication by themselves. Sometimes the nurses will have to administer that in a spoon, and there may be occasion that this person's medication coming out and they will have to do a few times. So is that something you're concerned about, that you actually pushing the medication into that person?
I'm grateful.
Danny Kruger.
I'm grateful. Once again, we are in this extraordinary no man's land between medical treatment and something else, which we can't find a word for. And the honourable gentleman is absolutely right. Of course, in medical treatment, it's very appropriate for a nurse or doctor to assist the administration of whatever treatment it is. And as he suggests, if the person is finding it difficult to raise a cup to their lips, the nurse would help them. Indeed, if they were finding it difficult to perform an injection, it would be expected, in fact, that that would all be done by the nurse or the doctor anyway. But here we're setting up some strange new method of administering a so-called treatment by which the patient has to take the physical act, perform the physical act themselves. And it is very unclear, as this clause is apparent from this clause, it is unclear what assistance actually looks like. So yes, I would absolutely imagine a nurse or doctor who's present at the final act in assisted suicide, if the patient is struggling to raise the cup to their lips, would help them to do so. Or if they're finding it difficult to put their finger on the syringe, that it would be appropriate, normally one would expect, for the medical professional to lift their finger and push it in the right place. What happens? Do they then apply a little pressure if the patient is finding it difficult to press the plunger on the syringe? If the cup's at the lips, do they tip it up and let gravity take its force, take its way? I mean, this very, very complicated, these complicated questions of where assistance ends and autonomy begins is, I'm afraid to say, impossible to specify in the Act. And therefore, we have this grey area, as is apparent here. Let me conclude with a little evidence that we received from Ian Brassington, who's the Professor of Applied and Legal Philosophy at Manchester University. I'll quote from him quickly. How are we to determine how the final act of self-administration is to be differentiated from the penultimate act, in which the doctor may assist? How would helping a patient lift the cup to her lips be distinguished from helping her ingest its contents, as the Honourable Gentleman says? The definition of the final act is unclear, especially granted the wording of this subsection. The proposed law says that a doctor may not administer a substance with the intention of causing death, but also that a doctor may help a person to self-administer. How should we draw the boundary between helping a person self-administer and playing a role in administration? And Madam Chair, if I may, just to conclude, I want to, well, penultimate point. This is the penultimate act, not the final act of my speech. There's very odd phrasing in subsection 7. I don't know if the Honourable Lady or the Minister can help pass the English here. So it says, the decision to self-administer and the final act of doing so must be taken by the person. So we understand about the decision being taken by the person, but the phrasing is the final act must be taken by the person. I'm just not familiar with that construction. I mean, do you take an act? Is that English? Does one take an act? No, you perform an act. An act is not taken. It is done by a person acting autonomously. So this question of whether it's an active or a passive concept, I think, runs to the heart of my concern about this clause. And I think we need to think about redrafting, at least in deference to the English language. There is somewhere here in this clause, there's a magic moment when assistance gives way to autonomy, when the penultimate act by the doctor yields to the final act, which is supposed to be by the patient. We can't tell the difference when the responsibility and the action passes from one to the other. And in proper medicine, it doesn't matter, because the medic works with the patient. Here it does matter. We are insisting there is a difference between the doctor setting up the death and the patient taking performing the action of suicide. And I will genuinely end with this point, Madam Chair, which is a reference to the case of R versus Kennedy. I think it was in 2008, which was a case in which Lord Bingham opined, and it was about the culpability of somebody who died from a heroin overdose. Was the person who gave him the drugs, tied the tourniquet around the arm, were they responsible? Was it murder or indeed assisted suicide? And the judge decided not, but the judge did make this point. Lord Bingham added, it is possible to imagine factual scenarios in which two people could properly be regarded as acting together to administer an injection. So given that ruling, I think we are in a world of difficulty with the suggestion that it's legally possible for a doctor to assist a patient to ingest or otherwise self-administer. To assist someone to self-administer is tantamount to administering. And I don't think it's possible. I mean, I welcome suggestions by other members or ministers or the sponsor about whether it's possible to provide guidance that gives greater clarity to what this clause means, whether indeed subsequent amendments will help resolve the problems that I have. But I'm afraid to say I don't think it will be possible to make an adequate distinction between the assisted suicide, in which full responsibility, not just of the decision but of the performance, rests with the patient on one hand, and euthanasia on the other. And as I've said, I don't think there is an adequate logical difference. And I'm afraid the practical difference that we are attempting to enshrine here will be very quickly obscured. Thank you.
Amendment 462 to clause 18, as on the amendment paper. The question is that the amendment be made. Ms. Shah.
Thank you, Chair. Can I thank the Honourable Member for East Wiltshire for his amendment, and certainly for speaking in the powerful way and the sensitive way that he did, and also the members for Spen Valley and Banbury who made intervention. I didn't intend to speak to this, Chair, but having heard the speeches in the powerful way and in the sensitive way in which children, I think it's important for me to share a few things. So the Honourable Member from Spen Valley has, I've heard a couple of times now, the difference between, when we're talking about suicide, the difference between people who are committing suicide and those who would be taking this route is because the people have been given, the patients have been given less than 6 months to live, and they're not choosing, that wasn't a choice. I just want to make sure that we understand. So I'm a former Samaritan. I was a Samaritan for years. And I was a Samaritan because I had 2 failed suicide attempts in my early years. And I've since then, I've battled with mental health demons all my life because of my life experiences. When people, to suggest there's a difference between somebody who gets a terminal illness and they want to take this act, and to suggest that people who are wanting to commit suicide are doing it out of choice, I think is wrong. And a reason I think it's wrong, and I felt really emotional when that exchange was happening, because at the time when I wanted to commit suicide, I didn't feel that I had a choice. I couldn't see a way out. And when I speak to people, being on those phone lines and the Samaritans, those people who ring and they're unpicking their feelings of what is driving them to feel suicidal in that moment, how they feel. They don't feel like it's not because they want to die, it's because they're in circumstances which drives them to feel they have no option but to commit suicide. In some instances, it takes the amount of courage and bravery to even contemplate that as an option. To diminish that, which I feel has what's happened on occasions, intentionally or not intentionally, I think it really is wrong. Because those people, I've been there, and it wasn't an easy, it wasn't because I wanted to die. Happy to give way.
Yeah, I think it's a really powerful point, and I think certainly I haven't heard anyone try and diminish the experience of suicidal people, and we probably all have our own stories of loved ones who we have either lost to suicide, I know I do, or people who have had very, very severe mental health issues. I think the point I would refer to is the families I've met who've lost loved ones through assisted dying or through a very harrowing terminal illness, death, have really desperately wanted to live. And I think that's the distinction I would make. But I appreciate, you're absolutely right, people with suicidal tendencies and ideation also want to live, they just don't feel they've got a choice. So I think it's a very delicate debate to have, but please be assured certainly of my sensitivities to that debate.
I thank my honourable friend for her intervention, and I'm genuinely grateful for it, because I do not want this committee or people, our constituents, to feel that there is an equivalence. No. Because there isn't. There genuinely isn't. And I don't think, people who are in that space, who ring the Samaritan's helpline, who speak, I believe everybody desperately wants a brilliant life. That's what brings us here, doesn't it? Each and every one of us to make this place the best that it can be, so our country is the best, so all our communities, all our people, all our constituents, all members of society thrive. So I'd just be careful to let's not make that conversation. It is a sensitive one, but there isn't a parallel. There isn't, and it can't be drawn. I just feel that was really important for me to put on the record. So I do want to support I will be supporting the members, the member for East Wiltshire in this particular amendment, simply because we've already turned down and voted against the amendment to simply ask the question, why? And I know, having been through my Samaritan experience, through somebody who's attempted suicide, through somebody who's gone on to chair a charity which leads mental health interventions, through that experience, and it speaks to the point that my honourable friend from Banbury raised. Now, if we find ourselves, a medic finds herself, who've gone through so much process where they've actually had that conversation with their family. They've had a conversation with their family who didn't necessarily agree with it, but they've taken that decision. They've convinced that family, do you know what, I'm going to take this option because I want that autonomy and I fear for it. But right at the last minute, when that family is there, I cannot imagine what it must be like for those people in that circumstance, at that moment, saying your final goodbyes, and the pressure, potentially, to have spoken to everybody, put everybody through this process, their family members through this process, indeed themselves through this process. And does that mean there can be that internal pressure on themselves to go through and not have the option and feel obliged, in a sense, to actually say, yes, this is... And so do we really want to not ask that question? I genuinely think this is a very, just like asking the question about why, there was this conversation, especially my honourable friend from Stroud mentioned, well, doctors will do this anyway. But in this instance, that argument wouldn't work, because doctors wouldn't do this anyway. Doctors wouldn't say, I'm about to give you something, and have you changed your mind? Because by that point, we're on a process. We're in that process where that drug is being handed over, drug or whichever form it takes, has been handed over to the person who has taken that option. So that's not the same. So I really genuinely hope the committee members will actually support this amendment, because I think that's that last option to make that intervention. Thank you, Chair.
Neil Shrestha-Hurst.
Thank you very much, Chair, and it's a pleasure to serve under your chairmanship, and I wish to speak very briefly to these group of amendments setting out why I support 462, 497, 498, but I'll be opposing 463. My honourable friend for East Wiltshire has set out very eloquently the reasons behind Amendment 462. And on the one hand, I feel there is a cogent argument to be made that it's not strictly necessary in light of the provisions set out in subsection 4, subsections B and C, which of course do set out that the individual who is wishing to have an assisted death must have a clear, settled and informed wish to end their life, and is requesting the provision for assistance voluntarily so. However, it does appear to me that there is both a logical and an entirely appropriate extension of the intentions which are contained within clause 18.4 to express those in slightly more explicit terms on the face of the bill. And by adopting my honourable friend's amendment 462, it strikes me that the bill would therefore be providing a further check and balance, which creates no greater onus on either the individual who is seeking an assisted death nor the coordinating doctor who is assisting. And in those circumstances, it appears eminently sensible to improve the bill in that way, in the terms that it's currently drafted. And from the indications we've already heard, Chair, it appears that there is significant support for that amendment. If I can turn to Amendment 463 and set out why I struggle with this amendment, which is, of course, to remove subsection or subsection C from clause 18.6. Now, the effect would be to prohibit the coordinating doctor from providing assistance to the person seeking an assisted death, either through ingestion or otherwise self-administration of that substance in any circumstance. In my view, this amendment would make the operation of this bill, if it was to become an act, unnecessarily restrictive. Clause 18.7 already stipulates that the decision to self-administer the approved substance and the final act in doing so must, and I stress the word must, be taken by the person with whom the substance has been provided. On any interpretation, Chair, of the construct of that, it is clear that the person who is seeking an assisted death must be the active participant in the process. It is mandatory. There is no discretion in that by virtue of the word must. Were we to remove clause 18.6c, it would have the effect, were this bill to pass into law, that it was, in what is an entirely legal process, a doctor would be unable to aid a patient in any circumstances. They wouldn't be able to hold a glass, for example. They wouldn't be able to steady a straw as a patient then moves towards it to imbibe the substance. Circumstances that are entirely foreseeable when, through the ravages of an illness, somebody is limited in terms of what they are physically able to do. But of course, assistance could be provided in alternative ways, for instance, through assisted technology that we have seen being used in other jurisdictions. The Swiss, for example, use a significant amount of assisted technology in administering and assisting the process of self-administration at the end of life. They can. I will give way to Mike.
I'm grateful to him. My point is that it's very difficult to draw a line here, and I mean I recognise the scenario that he places. Why shouldn't a nurse be able to hold a straw for a person to drink from? I might say that should be acceptable. I don't think it should be acceptable for the nurse to tip the pills up into the patient's mouth. Does he think that would be acceptable, that scenario? Or to give another one, to actively apply force on top of a patient's finger to suppress a syringe? Would he regard that as acceptable assistance?
Dr. Neil Shastri-Hurst.
Well, I'm grateful to my honourable friend for that intervention, but that is why I think the significance of subsection 7 of this clause is so important, because the final act must be undertaken by the person seeking an assisted death. Now, the examples my honourable friend gives of tipping tablets into a mouth, that is a final act. Pushing a syringe is a final act. There is a significant distinction between somebody, an individual, a practitioner holding a cup with a straw, and the person seeking an assisted death moving their mouth towards the straw, sucking from the straw and imbibing the substance, from the passive act of a substance being raised to that individual's lips and poured in without any movement by the individual themselves. I will give way to my honourable friend.
I'm grateful. I mean, this might, when we talk about the future debates, it might be appropriate for this conversation to be referenced. So I think he's suggesting that it should be acceptable, assisted death would be legal as long as the patient moves their head towards the straw, towards the cup. It would be illegal if a cup were being administered to a patient to their lips and it passed the point of gravity, at which point, if the doctor were applying the cup to the lips and the drugs fell in by gravity, that would be illegal, I think, according to his definition. So, is that right? Is that how judges in future should determine whether assistance has crossed the line?
Dr. Neil Shastri-Hurst.
Once again, I'm grateful to my honourable friend for his intervention. I think it's very clear, as I say, from subsection 7, that this must be an active step taken by the individual. There is a risk we go down a rabbit hole in terms of... I'm sure my honourable friend would like me to finish the point. We go down a rabbit hole in terms of drawing the example that I raised myself of a cup, but of course there's much wider assistive technologies that can be used and are used in different jurisdictions. I give the example to illustrate the point that this is, as I say, an active act and not a passive act. There is an important... I will give way.
Just
Roberts.
He mentioned subsection 7, but subsection 8 also states quite clearly does not authorise the coordinating doctor to administer an approved substance to a person with the intention of causing that person's death. And I think the passive and active roles here are quite clear between these two subsections.
I'm grateful to the honourable member, and I agree entirely in terms of her interpretation of the bill as it's currently drafted. But there is a further unintended consequence of my right honourable friend's amendment that I'm sure is not his intention, but it is sadly the effect. And that would be that were an individual to qualify under this act, should it pass, they would inevitably, if this amendment was to bite and to be adopted, they'd inevitably be forced to take that final decision at an earlier stage. Because if there is a restriction that they can have no assistance whatsoever in doing so, they are going to end up making that decision when they know they have the entire physical strength available for them to do so, which actually brings forward the point at which they choose to die to an earlier stage. I'll give way to my
I'm very grateful to my honourable friend. He's making an extremely strong point. After 10 years of campaigning on this issue and spending so much time with people whose family have gone to Switzerland, one of the things they consistently say is that people went to Switzerland much earlier than they really wanted to, because they had to go while they were still physically able. And I do think this is a critical point that people have to realise, that we should not compel people to do this earlier than they otherwise wish to, simply because of these restrictions.
Dr. Neil Shastra-Hurst.
My right honourable friend makes a very important and powerful point, and this is where I think there is a consensus amongst this committee that this is, there is not a desire for people to be taking this ultimate step at an earlier stage than is absolutely necessary for that individual. And by adopting this amendment, it is my very real fear that we will be bringing forward that point of decision. I will give way to my honourable friend.
I'm grateful. The logic of that argument then is to allow physician-administered suicide, because there will be a point at which people are physically unable to perform the act, but they will have capacity and their autonomy should be respected. Does he...
Order, order. It being 11:25 a.m, the committee is now